One of the most perplexing things about British immigration law and policy currently, one could argue, is the requirements as it relates to the financial requirements for a spouse visa or a partner visa or a settlement visa, or really the same thing. It is an application made under Appendix FM, generally of the immigration rules. Basically an application initially for what's known as entry clearance. So you apply from abroad in order to get permission to enter the UK as the partner or spouse of a British citizen. This would also apply potentially to your children. If your children does not also hold British nationality or does not qualify to be registered as a British citizen, and so forth. It is important to note that there are options oftentimes that apply to children that folks are just unaware of. Get legal advice on that, because oftentimes you could maybe register your child if your child isn't a British citizen by descent. For example, if a parent was born abroad, so that parent is British by descent, but lived in the UK for more than 3 years and then left the UK, and the child was subsequently born abroad, that child could be registered as British, which would obviate the need to apply for a settlement visa. Now, what is a settlement visa? Effectively, it is a visa that leads to settlement, right? So also known as indefinite leave to remain, which effectively means you're free from immigration restrictions and have the ability in due course to apply to become a British citizen, generally by way of what's known as naturalization. It's a 2.5-year visa that gets extended by 2.5 years. At the end of the 5 years or 60 months in total, one applies for indefinite leave to remain and subsequently citizenship. The question now is, well, how do I apply and what are the requirements? I'm only going to deal with the financial requirements as a general overview, and separately at a later date, I will deal with some of the other requirements. The financial requirements introduced some time ago and updated in 2024 effectively is the way for the government to ascertain that you'll be able to apply for a visa without having to claim benefits, right? That's sort of the basic premise of it, I would imagine. Now, there are various ways of satisfying the financial requirement. These requirements are divided into different categories, A, B, C, and so forth. In short, a summary of the different ways one could meet these requirements can be seen as either the British citizen living and working in the UK, earning above £29,000, depending on circumstance, but generally on an annual basis. Now, within that requirement, there are different ways of meeting that requirement. So, for example, if the British citizen is self-employed, that changes and it becomes infinitely more complex potentially. And you have to bear things in mind like tax years, how the taxes are submitted, what deductions are made prior to the taxes being submitted. The government tends to look at taxable income. If, however, the British citizen is employed on a pay-as-you-earn basis with a company, it tends to be much simpler to satisfy the requirements. Now, does that mean if you live abroad that the British citizen has to leave you and go to the UK in advance? Not necessarily. It's also possible to apply based on maybe the British citizen's income from your home country with a job offer for the UK. It generally does depend on circumstance. Don't assume, get legal advice, double check, make sure that there won't be effectively what is deemed to be a forced absence that is not required if the British citizen moves to the UK first in order to start working. There are also different ways of satisfying requirements by combining different types of income or relying on savings or certain qualifying investments, if they're liquid, that you can rely on. If you have a portfolio, equities or whatever, and you get dividends, you can rely on that as non-employment income or interest from savings potentially, or if you have an investment property from rental income. There really are a number of ways of satisfying these requirements. If none of these requirements are possible to satisfy, there are alternative options, but they're very much outside the ambit of this video. But get in touch with either with us or with somebody like us who will be able to assist you on potentially the discretionary aspects of these type of applications, especially if there are children involved. Now, the same requirements pretty much would be required to be met upon the extension phase. Bear in mind, it's an initial grant of leave of say 2.5 years, and then one has to apply for extension to take you up to the 5 years. If at that stage, for whatever reason, you don't meet the requirements, again, there are options there, different to the entry clearance options, but options nonetheless, but it does get rather complicated, and it could potentially mean that you will be put on what's known as a 10-year route to settlement, as opposed to the normal 5-year route to settlement. If all the requirements are met, however, And the requirements can be met in a different way. For example, if you relied on cash savings for the entry clearance application, but you've used that cash savings to invest in a property or buy a property or whatever the case might be, but subsequently there is employment income that would qualify, then you can rely on that employment income instead of having to rely on the cash savings that you relied upon potentially for the initial entry clearance application. The application can be done in country because you're already in the UK, right? You've already have your entry clearance. Now you're applying for what's known as further leave to remain. At the end of that period, finally, as the law stands today, you'll be eligible to apply for settlement, definite leave to remain, also known as permanent residency. Different application again. Bear in mind that the requirements are different. I will touch on that in a separate video, but it is very important to understand that just because your entry clearance is granted, so that first visa we spoke about, does not mean that the extension application will automatically be granted. And it does not mean that your indefinite leave to remain or settlement application will automatically be granted. There are laws and requirements that need to be met all along the way. And it really is important to ensure that you attend to those, keep your records and so forth, in order to ensure a successful application for your indefinite leave to remain. Where do things tend to go wrong when it comes to settlement applications, right? That indefinite leave to remain generally after 5 years if you are on a spouse visa under Appendix FM of the immigration rules. Generally speaking, it's important to remember that there are rules along the way, requirements that need to be met. These requirements change, the law changes, policy, guidance, the political environment, all of these things affect the requirements and the chance of success with any immigration application. Once granted settlement, as long as you aren't absent from the UK for too long a period at a time, and as long as you didn't use fraud or anything like that to obtain your settlement, it is what it kind of says on the tin, indefinite leave to remain. You are free from immigration restrictions. So the government really look at the settlement applications even more thoroughly than they do, if such a thing is possible, that they do with the extension applications or the entry clearance applications, because that's the last time immigration will look at you. The next application will be for naturalization under a whole different body of law. With settlement applications, there are requirements. You've got to do the life in the UK test. There's an English language requirement. You still have to meet certain financial requirements, though that is different from the extension application as it relates to savings, for example. It's also really important to keep track of your days of absences. If you've traveled too much out of the UK, your long-term intention to remain in the UK could be questioned, and that could lead to a refusal. Or you might have to extend your application or your status another time until you have enough time spent in the UK without having traveled too much to still be able to apply for your settled status. The relationship still has to be subsisting, because that, of course, is the basis upon which somebody is in the UK as the spouse of a British citizen. You also have to show that you still have accommodation that you own or occupy exclusively. So although the requirements seem the same, they are similar, but they are not the same as it relates to entry clearance, further leave to remain, and then settlement. If circumstances change, for example, if the relationship doesn't work out, or if there is domestic abuse or anything of that nature, it really is important to take legal advice as soon as possible. There are different rules and requirements and options available, but it's outside the ambit of this video.